hear ye, hear ye. All manner of persons having anything to bring before the honorable justices of the Supreme Court of the state of Delaware will now draw near and give their attendance. The court is now open. God save the state and the honorable court. Please be seated.
Good morning, everyone. Welcome, Capitol Police. Thank you for being here today. Introductions.
Good morning, Your Honors. May it please the court, I'm Cliff Gardner at Skadden, Arp, Slate, Marr & Flom. I'm here today on behalf of the Appellees. With me at council table are my colleagues Andrew Kinsey and Mallory Phillips.
Welcome.
Thank you.
Thank you.
Mr. Chief Justice, Your Honors, good morning. Tom Curry from Saxena White on behalf of the plaintiff appellant. Start with a few brief introductions. I have with me today Gregory Varallo from the Bernstein-Litowitz firm, Andrew Blumberg from the Bernstein-Litowitz firm, and David Tejtel from Freeman Oster and Tejtel.
Welcome.
And so with that, may it please the court, Your Honors. Plaintiff appeals from a pleading stage dismissal of a minority stockholder challenge to a controller squeeze-out in which the minority received consideration valued at least $46 per share below the price that a credible, arm's-length market buyer was willing to pay for the company. We submit reversal is mandated for two independent reasons. First, where a credible and materially superior topping bid emerges from a market buyer, judicial cleansing under MFW would be fundamentally inconsistent with the policy and premises of that doctrine. But second, even if judicial cleansing under MFW could theoretically apply in these circumstances, we don't believe that it was properly applied here. We believe that in holding otherwise, the court below failed to credit well-pled allegations and also, in some cases, granted defense-friendly pleading stage inferences, and that provides an independent basis for reversal. Now, if I can, I'd like to start with a brief recitation of the critical facts. Eidos was a development stage pharmaceutical company. It had a single product under development that was on the verge of commercialization. The problem was Eidos did not have the capacity to independently commercialize that product. It was a company essentially built to secure a deal with a larger player. And the company's controlling stockholder, BridgeBio, wanted that deal to be with BridgeBio. Now that plan and that desire faced a serious threat in the summer of 2020 when GlaxoSmithKline, one of the world's largest, most successful, credible pharmaceutical companies, approached the company, conducted diligence, and submitted a proposal for a multi-billion-dollar collaboration deal. BridgeBio and the dual fiduciaries in the company's C-suite and on its board perceived that proposal as a threat, and they reacted defensively. They pushed the GSK proposal aside. They never presented on its merits to the independent directors, and they instead, within days, initiated a confidential, purported MFW process that ultimately resulted in a deal valued at $73.26. Almost immediately thereafter, GlaxoSmithKline protested having been shut out of that process, given that it was there on the front end, and it made clear that it was willing to provide significantly greater consideration to Eidos stockholders, at least $120 for a full company deal, which would have represented a 64% premium to the deal struck with the controlling stockholder, BridgeBio. BridgeBio, however, viewed $120 a share as inadequate to even warrant negotiations for a sale of its own shares in the company, and it made clear that it was uninterested in any deal with GSK, no matter the price and no matter the form. It was also uninterested in collaboration deals. Faced with BridgeBio's intransigence, the committee ultimately cut off negotiations with GSK, allowed the underpriced bid to go to stockholders, and it was subsequently approved. We submit, however, that it was approved in circumstances that were situationally coercive and was also approved on the basis of proxy disclosures that were materially deficient, misleading in some cases, in others, just plain false, at least based on pleading stage inferences. And so, with that stage set, let me turn to my argument. As I think this court knows, in the controller squeeze-out context, there typically are, and in fact, there's almost always, a lack of third-party bids that the court can look to in order to assess a transaction's fairness. The MFW doctrine was adopted against that backdrop, and its fundamental premise is that the dual protections can be trusted to replicate arm's length bargaining, produce a presumptively fair price consistent with what one would reasonably expect from a third-party arm's length transaction, and thereby obviate the need for entire fairness review. That premise, however, we submit, fundamentally collapses in the rare situation, very rare situation, where objective evidence demonstrates that the dual protections just simply did not work.
What, aren't you essentially asking us to overrule MFW altogether? Because in MFW, McAndrews and Forbes had 43%, and they stated in their announcement that they were unwilling to sell. And as a practical matter, the court noted that their block was large enough to preclude another bid. So don't we have to completely overrule MFW in order for your theory to work?
I don't think so, Your Honor. We do not submit that controllers have any duty to sell or that they automatically face liability if they refuse to sell. But what we do submit is that when compelling market evidence in the rare form of a materially higher credible topping bid comes in, that at least for pleading stage purposes demonstrates the unfairness of the transaction and the fact that protections just did not work. In that case, the action should go forward and there should be a trial on entire fairness. Now, I think...
So just help me out here. I mean, the free will of the stockholders here, let's put aside your disclosure coercion for a second, just because we're talking theoretically on how MFW might apply in this instance. What's wrong with leaving it to the minority stockholders to reject it?
So, Your Honor, I think there is a reason that a stockholder vote standing alone is viewed as insufficient protection in the controller squeeze-out context. That was explained very clearly in Kahn versus Lynch, and I think was reaffirmed in the MFW line of cases, which realize that you need to have both protections and they both need to work. And the way we look at this case, once the topping bid comes in at a 64% premium to the deal struck with the controller, and that topping bid, by the way, is an initial proposal. GSK is willing to go higher. How much higher, we don't know, 150, 200. That demonstrates that already, before the deal even goes to stockholders, the protections just have not worked. And then the minority stockholders are sort of in the disaggregated context that precludes cleansing based on a vote standing alone under Kahn versus Lynch.
Does your argument depend upon the existence of a topping bid? And the reason I ask you that is you keep saying the MFW framework didn't work. So it seems like you're working backwards from the result. But what the extension of that argument would be, no topping bid, but the price is clearly unfair. It didn't work. So help me understand how this rule or how your argument plays out when someone comes in and says, well, this price was obviously unfair, therefore the process didn't work, therefore MFW should not apply.
So I think one way to look at it is to sort of walk through the cases of how we got here. I think if you look at this court's opinion in MFW, that there was a real sense in that case that we can count on these protections to work at least most of the time, but I think there was some sense in that opinion that there needed to be a safety valve for situations where a deal came in and just looked on its face clearly unfair. Now the problem was that that sense was ultimately fulfilled in footnote 14, which we learned later what was not up to the task, because as cases like Swamley and Sinutra demonstrated, viewed that way, it effectively allowed any stockholder plaintiff to come in with routine fairness arguments that could be raised in any case. They didn't value the patent assets correctly in Swamley, the projections were off in Sinutra, and I think this court correctly realized that if you can raise that type of unfairness, those types of unfairness arguments at the pleading stage, that should not be sufficient to get you over a motion to dismiss, because then MFW would have no utility. You could raise arguments like that in every case. What we submit is that a topping bid at least a 64% premium to the deal struck with the controller, this is a unique type of evidence of unfairness. It's evidence that I think is particularly salient, given the recognition of this court in MFW and elsewhere of the importance of the market value, what a market buyer would pay. And it's different in kind, not just degree, from the type of evidence that was at issue in a case like Swamley or a case like Sinutra.
So how does the entire fairness case play out then? Because you would say, okay, the evidence of damages would be what, this higher offers that come in, even though there's no obligation by the controller to accept these proposals.
I think in an entire fairness case, the GSK proposal, and maybe in particular the $110 proposal that GSK made just for the minority shares, not including a control premium, that would be at least extraordinarily strong prima facie evidence of what the fair value of this company was. You can sort of hypothesize arguments defendants might make to try to rebut that. GSK is just crazy. Their value of this company is totally untethered from reality, even though BridgeBio itself doesn't view 120 as a sufficient price to warrant negotiations for a sale of its own shares. There could still be arguments, but there's no doubt that in an entire fairness trial, a third-party bid just for the minority shares at a premium 50% above the deal price struck with the controller, not even the third party's final bid, I think that would be extraordinarily strong prima facie evidence of unfairness. And so the question now is, on a complaint where that type of evidence exists, where I think almost anyone can look at this and just see the unfairness. A third party would pay $110 for the minority shares, put aside a control premium. The controller's buying it out opportunistically for $73.26. The question is, does the court have to blind itself to that type of compelling market evidence that is very different from the type of evidence in a case like Sinutra or Swamley that would require the court to get into the weeds and apply its own business judgment to the valuation of patents or projections and try to weigh how that all sort of comes out in terms of a full company valuation. Here we have
Isn't the very idea of MFW confirmed in cases like Sinutra that when the MFW framework is employed at the front end of a deal, the court is not going to look at the economics of the deal itself? And if we start looking at the economics in particularly strong cases and start chipping away at the MFW framework, doesn't that disincentivize controlling stockholders from using the framework altogether?
So I don't think that Sinutra, cases like that, Sinutra and Swamley, preclude this challenge. I think this is a fundamentally different and very unique type of evidence that doesn't require the court at the pleading stage to be applying its own sort of independent business judgment to weigh routine fairness arguments. I also don't think that a ruling that in the extraordinarily narrow circumstance of a dramatically higher topping bid precludes application of MFW. I don't believe that would chip away materially at the doctrine. I cannot emphasize enough how rare this situation is. I can't think of another single case in this court's history where there's been a controller squeeze out that was subsequently topped by a bid of this magnitude. The first price on the table is 64% above what the controller was willing to pay. I think this would be a rule that would apply in extremely rare circumstances, maybe even never again.
But where do we draw the line? How do we know? You keep saying prima facie, but where would this line be drawn if you could draw it yourself?
I think it would apply strictly to this unique type of evidence, topping bid, and I think it would have to be a credible bid, and it would have to be materially higher than the deal struck with the controller. And I think credibility, materiality, that they are ultimately factors that you sort of know when you see them, and courts, including this court, sort of apply materiality determinations at the pleading stage in other contexts. I think Vice Chancellor Laster did a version of that in Books-A-Million, where he looked at a potential topping bid that was, I think, around a 30% premium and said, it's not really a topping bid because all it's really doing is accounting for a control premium. That's obviously not an issue here, where there was an offer for $110 just for the minority shares.
But your friends, in their brief, make the point that there were strings attached to the 120.
There were, yes, and there were strings attached, I'll admit, to the 110 for the minority shares. But I think that $110 offer was a greater than 50% premium over the BridgeBio deal. I think even assuming a fairly significant value attached to those governance strings, as you put it, that the committee viewed as reasonable, it would be hard to say that that's accounting for the full difference between what GSK is offering and what the controller ultimately acquired the shares for.
So just help me understand what the committee should have done in this case.
Look, the committee here, if I had to point to one failure, it would be, and I think it was a failure that was not entirely the committee's fault. I think it was in part a result of disloyalty by the dual fiduciaries in Eidos' C-suite. But the record here is that a proposal, a multi-billion-dollar collaboration proposal from the most credible third party in the world, a proposal that would not have required BridgeBio's approval, came in 2 days before the MFW process started, and there is no evidence in the record that it was ever even considered by the special committee. It's not just that they didn't reach out and decide to negotiate with GlaxoSmithKline. There is no evidence in the 220 record that it was ever even considered. But I think that is not the only, or maybe even the strongest reason that we think MFW, even if it could theoretically apply, was not satisfied here. I think I'm obviously not going to be able to address all of our arguments for why MFW did not apply, but I think I'd like, with the time I have remaining, to talk about some of the issues concerning the vote. And so I think first, we think this vote was put to stockholders in undeniably situationally coercive circumstances. GSK and BridgeBio, smartest money imaginable, both have skin in the game, clearly valued this company in excess of $120. We don't know how much higher, but significantly in excess of $120. And yet, Eidos stockholders accepted consideration valued at less than $74 per share. And so the question is, why? And I think logically you have to assume either there's a degree of economic irrationality here, or there was something uniquely unattractive about the standalone option. And I think there was. I think there were circumstances here that I think fit neatly into the type of situational coercion that was outlined by Vice Chancellor Laster, kind of bringing together a line of cases in the Dell motion to dismiss opinion, where he sort of emphasized that there needs to be a higher degree of scrutiny on the circumstances surrounding a vote that's going to have a cleansing effect in an MFW context, where there can be coercion that maybe does not rise to the level of a fiduciary breach. It doesn't need to be direct threats. The way he sums it up is that the situational backdrop of an unacceptable status quo does not give rise to a fiduciary breach, but it calls into question the meaning of a stockholder vote such that it should not be given cleansing effect. And we think we have here alleged particularized facts establishing that the latter situation is what happened here. The court below ruled this situation was not coercive because an independent launch was viable, that Eidos had options besides doing a deal with someone. Now, we think that is an unsupported, defense-friendly inference or factual finding made at the pleading stage. I think it's contrary to our well-pled allegations, paragraphs 46 to 48 of the complaint, and also to the special committee's own representations to stockholders. We put in the, or I think defendants may have put in the record, a presentation that the special committee made to ISS when it was soliciting support for this vote. It's at A578 in the record. The special committee explicitly warned, voting down the BridgeBio transaction right as Eidos enters a critical phase of clinical development would carry significant risk for Eidos stockholders, given that a successful product launch requires development of core multidisciplinary capabilities years prior to launch. And that's a process Eidos had not even started. In fact, that same slide at A578 says that if Eidos were to remain a standalone, the company would need to dilute its existing stockholders in order to raise the immense amounts of capital that would be needed to ramp up in this way. So the court said that the standalone option was a viable alternative. We disagree. The court also said, in rejecting the coercion argument, that maybe even if the standalone option was not viable, a sale to someone other than BridgeBio wasn't viable, there may have been other alternatives. And I think what he was referring to was the possibility of a collaboration deal, like the one GSK had initially proposed. Which brings me, I think, to a disclosure argument that I'd like to cover. If you did, as a stockholder, think you had the available alternative of doing a collaboration deal with someone, the obvious someone would be Company C, as GSK was described in the proxy, and the most material fact, I think, would be, well, what are their capabilities in commercializing this product with us? Can they really do it? Because we can't, we need someone who does. And what information would a stockholder find in the proxy to inform them at all as to whether Company C was actually a good company to partner with for a collaboration deal? The only description of Company C in the proxy is a report or a description of a BridgeBio board meeting describing Company C as not a suitable collaboration partner for acromitis because of its lack of presence in cardiovascular and rare genetic diseases. Now, I agree that the part of that language that I just read, not a suitable collaboration partner, that was described in the proxy as BridgeBio's opinion. But I believe if you read the proxy closely, I believe it's at A245 to 246 in the record where this statement is made, the lack of presence in cardiovascular and rare genetic diseases, that is stated as if it were fact. And I think we allege in the complaint in some detail with slides from GSK, paragraphs 132 to 135, the notion that GSK had a lack of presence in cardiovascular and rare genetic diseases was simply false. They had significant experience and expertise in those areas. And I think what that disclosure really did was paint Company C as just a total stranger to this field. And I think, and maybe to this disease that Eidos's drug was going to treat. And that could not be further from the truth. As we allege in the complaint, GSK, of all large pharmaceutical companies, had the most experience with studying this particular disease. I think the complaint supports a reasonable inference that GSK was the ideal collaboration partner for this company. But if you were a stockholder, you recognized, as the trial court suggests you would have, that a collaboration deal was an available alternative that you could have taken instead of selling out to your controller because the standalone's not viable. And you went looking for information on Company C. Who is this? Can they really deliver value? The only language you see is not a suitable collaboration partner, lack of presence in cardiovascular and rare genetic diseases, which was false. And GSK specifically brought that to the attention of the special committee. They submitted a letter the day this disclosure came out and said that's false. And it was not corrected and it was not supplemented. I'm into my rebuttal time. I'll reserve the rest of my time. Thank you.
Thank you.
Good morning, Your Honors, and may it please the court. The plaintiff has taken the position that you shouldn't even engage in an MFW analysis, even though this entire transaction was structured to comply with that case. So I want to shoot that down right out of the gate today. BridgeBio was Eidos's controlling stockholder, and it made an offer for the minority shares it did not own. Right at the outset, exactly as this court instructed, BridgeBio took away its ability to dictate the outcome of that transaction. It promised in its very first overture it wouldn't proceed with the transaction unless approved by an independent committee and a majority of the minority shares. That is exactly the situation in which MFW applies. Now, the application of MFW, when we get to the courtroom, is the entire reason a controlling stockholder disables itself at the beginning of negotiations and turns the question of whether to sell those minority shares over to the stockholders themselves. That's the incentive. It's precisely what this court said in Flood. Yet plaintiffs say today, you shouldn't apply MFW. You shouldn't do exactly what MFW says you'll do, because our client, BridgeBio, refused to sell its shares into a third-party offer for the entire company. Plaintiffs have no case law to support that theory. This court's law in an unbroken string going back at least to the Bashad case have said that controlling stockholders have no duty to sell their shares if they decide not to do so. It's a core tenet of our law. I don't have to sell my house at any price if I choose not to. This was also true in MFW itself, as the court noted. The controller said in its very first offer in MFW that it had no interest in selling its shares. This was true in Flood v. Sinutra. This was true in Books A Million. Yet this court affirmed the application of MFW without any pause over that fact. So what does plaintiff say next? Plaintiff says, well, this is a rare case or an unusual case because a third party tested that controller's unwillingness to sell. But that's not accurate either. This exact same thing happened in Books A Million. In Books A Million, Party Y offered a credible, materially higher offer for the whole company. The controller stood on its position that it wouldn't sell its shares. The court below applied MFW loyally, and this court didn't hesitate to affirm that application. So, plaintiff pivots again. It now says that there's a special, particular type of pleading that they presented, a special, unique one that you can look at on a pleading and decide that's the circumstance, that's the magic pleading in which you won't apply our case law. So I want to test that today, because here's the pleading they say they brought you. They say that a third party has made what they call a, quote, apples to apples offer to the BridgeBio offer. And they say that apples to apples officer is clearly superior. That's the word I heard today. It conclusively demonstrates, that's the other quote, that the bridge offer was unfair, far beyond a range of fairness, they say. They say that no judge would need to use its independent business judgment to figure that out. So let me test that. In the transaction, BridgeBio offers to buy the minority shares of Eidos, and for each share, BridgeBio will give either 1.85 shares of a BridgeBio common stock, it's publicly traded on the NASDAQ, or $73.26, subject to a cap on the cash and proration if it's oversubscribed. That's the BridgeBio offer. GSK offers $110 in cash for each minority share, plus a suite of governance rights. Governance rights the minority has no ability to sell, governance rights that requires BridgeBio to self-sacrifice and donate them to the cause. Those are the two offers. I don't think those are apples to apples at all. First, they're not even trying to buy the same thing. BridgeBio wants to buy a minority share, period, full stop. GSK wants to buy a minority share and a suite of governance rights. The Vice Chancellor gathers these at page 19 of his opinion below. It's footnote 90. They want a right to appoint two directors. They want the right to make decisions about future transactions. They want certain assurances about how they'll be treated, GSK, if the company goes private. None of this the minority can sell, and none of this BridgeBio is trying to buy. And they're not offering the same consideration either, right? GSK is offering $110 in cash, period. BridgeBio is offering either 1.85 shares of BridgeBio common stock publicly traded on the NASDAQ or $73.26 in cash, again, capped and prorated. So those aren't the same considerations. And by the way, we all know those 1.85 shares of BridgeBio common stock, every day that market price can change. Perhaps it is, you view this as a long-term hold. It's a totally different proposition than $110 in cash. And by the way, and you'll look at Appendix B82, about a month before the vote, those 1.85 shares of BridgeBio common stock that you can get for one minority share of Eidos, they're worth $125.65. That's again, at B82 in the record. The committee recognized that when it decided to continue to recommend the transaction as the best interest of the stockholders. So I think plaintiffs are just dead wrong that you can look at these two deals, conclude they're exactly the same, conclude that the court won't have to get into the weeds and figure out which one's more valuable, or which one's fair, or what. And I think they're dead wrong that this GSK offer illustrates that the bridge officer is far beyond a range of fairness. In fact, I think what plaintiffs have shown you with this example is exactly why MFW and the business judgment rule works the way it does. Because who should decide if one share of IDOS minority stock is a good deal to trade for 1.85 shares of BridgeBio common stock traded on the NASDAQ? Not a law-trained judge, respectfully. It's those minority stockholders themselves. And that's what MFW accomplishes. MFW guarantees that the person that makes that decision is the owner of the share, exactly how it should be in our law. Here's what the court said in Flood. It's a quote. "The whole point of MFW is to give a pathway whereby judicial review of the economics of the transaction can be avoided if the correct parties, impartial directors and minority stockholders themselves, are given the appropriate authority." That's precisely what my client did. That's precisely this court's guidance. The court below recognized that. It loyally applied MFW. It applied the business judgment rule, which is the output of MFW. And under the business judgment rule, we do not second guess the fairness of the transaction. And it dismissed the case. We'd ask that you affirm that analysis on appeal. I welcome questions on this first policy point. So with that, let me proceed to the handful of disputes that plaintiffs raise on appeal with that application of MFW. MFW has 6 elements, as you know. The first is the controller disables itself ab initio right out of the gate. There is no dispute that our client did that. The second is that the special committee be independent. There is no dispute that the special committee was independent here. Third, the special committee must be empowered to pick its own advisors and definitively say no. There's no dispute that occurred. The committee employed Cravath as its legal advisors, Centerview as its financial advisors, and retained an industry expert to understand the marketing of pharmaceutical products. The last 3 factors, the special committee must meet its duty of care, the vote must be non-coerced, and it must be fully informed. And those 3 elements are the ones at issue according to the plaintiffs. So let me start with care. The plaintiff says the committee breached its duty of care by failing to engage with GSK before agreeing to the transaction. Your Honors, that is undoubtedly a tactical choice, and challenging that is foreclosed by Flood. In Flood, the court held that, quote, disagreeing with the committee's tactical strategy is not a due care violation. Due care is established by showing a defect in the deliberative process, the way the committee made that decision, not the outcome of the decision. So here, as the plaintiffs admitted below, you'll find it in the record at Appendix B53. Plaintiffs admitted below, nothing prevented the committee from reaching back out to GSK. Nothing other than a tactical decision that those independent members made with their bankers and their lawyers. At that point, a care claim must fail. Next, the plaintiffs say that Dr. Kumar, a dual fiduciary, caused the committee to breach its duty of care because it withheld material information from the committee. That's opening brief at 35. This theory is not well pled in the complaint. The opening brief doesn't cite a single allegation from the complaint showing that Dr. Kumar or anyone else interfered with the committee's process. Not one. The court recognized that below at opinion page 38. And there's no allegation of what information the committee needed that it didn't receive. I'd like to read for you the entirety of the plaintiff's pleading on this point. It's found in a footnote in the complaint. I didn't brief this below. Quote, notably, GSK's subsequent correspondence to the special committee indicated that GSK followed up the August 16th collaboration proposal with additional materials in support thereof. Specifically, its November 23rd, 2020 letter indicated that, quote, we submitted a collaboration proposal followed by detailed materials. That's it. That's not a pleading about an informational deficiency. There's no indication of what information was withheld from the committee. That's not a pleading that shows you there was gross negligence in the deliberative process by approving this transaction. Was this information public information that the committee already had? Was this information duplicative of the information the committee got from its own advisors? This is not a well-pled allegation. And here I'll note that plaintiffs analogize this to RBC versus Jervis, right, where there are specific things withheld from the board, right? The board was deprived of the fact that RBC was working a buy-side financing role, very specific withholding, very specific fact that leads to gross negligence. There's no similar pleading here. So next, plaintiff says the committee prematurely cut off negotiations with GSK. I'd like to start with the concession in that argument, which is the committee did in fact go negotiate with GSK. After it reemerged, the committee declared that GSK could lead to a superior proposal and engaged with GSK, held numerous meetings. The Vice Chancellor recognized in Books and Milne that that act definitively undercuts a care analysis because the committee engaged with GSK. Plaintiffs say, well, they should have engaged further or longer or more. That's classically a tactical disagreement that is foreclosed by Flood. Your Honors, I'd also point out that this idea the committee cut off negotiations isn't exactly what the plaintiffs plead. If you look at the trial court's discussion at page 37, a December 11th letter from GSK says, we're not willing to make any further offers, to which the special committee responds, if you'll make some, we'll consider them. The plaintiffs admit that in their opening brief at 41 as well. So finally, Your Honor, the court made clear in Flood, care is a process-based analysis. It is about the deliberative process. It's not disagreeing with outcomes. It's undisputed the committee members were independent. The committee hired independent advisors. The committee negotiated multiple price increases. The committee met 15 times with those advisors before approving the transaction and met another 9 times afterwards. That's the end of the care analysis under this court's decision in Flood. So let me briefly touch coercion. The plaintiffs say this is situational coercion, like in Saba Software. Okay. In Saba Software, just ahead of the transaction, the board members, having been derelict in their duties, are sending the company into a delisting and a deregistration of the shares. They quickly accept a transaction below the trading price, and the stockholders are forced to choose between that transaction below the trading price of their shares or to be delisted. The plaintiffs here have pled absolutely nothing similar to that. They've not pled any threat by BridgeBio whatsoever. If this transaction doesn't go through, that's classic coercion, but they don't plead that. And they plead something else that I think is very unique and damning to their coercion argument, and it's this. Back in 2009, the plaintiffs plead, BridgeBio made an MFW-compliant offer, and the special committee rejected it. They said no. And after that, BridgeBio didn't make a single threat, didn't make a single retributive act, didn't do anything to disrupt Eidos's progress towards commercialization. If you look at paragraph 45 of the complaint, here's what they allege. Quote, Eidos thereafter, after rejecting that MFW proposal, Eidos thereafter continued to successfully develop acromidas and advance the drug towards approval and commercialization. That's at paragraph 45. So that's the status quo. Now plaintiffs say they weren't doing a good enough job, they weren't doing fast enough, it wasn't an ideal situation. But what the court says in the Swamley case is it doesn't matter if the status quo is relatively unattractive. As long as the stockholder can say no to the transaction and return right back to where they were, unattractive as it might be, there is no coercion.
Could you, while you're on this point, ask you to address your friend's argument that when the Court of Chancery determined that the go-it-alone alternative was a viable one, that it was drawing inferences in the wrong direction, that it was a defense-friendly inference?
Thank you for the question. I think that's absolutely not what the Vice Chancellor did. I think the Vice Chancellor is relying on the actual pleading the plaintiff gave his honor. At paragraph 45, the plaintiffs had pled that Eidos was on its way to successfully commercialize acromidas. in advance of this transaction. I think the Vice Chancellor recognized the argument that that process might not have been going as ideally as the plaintiffs would like, but he was clearly crediting exactly the allegations made in the complaint, that Eidos was on that path. So with that, with my remaining time, let me briefly turn to the disclosures. And of course, we start by reminding ourselves that when we look at a disclosure allegation, we must read the proxy as a whole, and we consider the entire disclosure. And we ask ourselves if the supposedly omitted fact would significantly alter the total mix of information that stockholders had. So here's the information the stockholders had. The proxy statement disclosed roughly 25 single-space pages of background leading to this transaction. A supplement added another 7 pages of disclosure, including bringing all of those interactions with GSK current. Plaintiff doesn't dispute that the terms of the transaction itself were presented fairly to the stockholders. Plaintiff doesn't dispute that the financial advisor's work that the committee relied on was fairly presented to the stockholders for their consideration. They don't dispute that the GSK offers were also fully disclosed, that the stockholders knew that GSK had offered $120 a share and my client had said no thank you as to its shares. They knew GSK had offered $110 per share for, again, the minority share plus the governance rights, and my client had said no thank you as to its position. And they also knew that GSK had offered roughly $2.4 billion in an upfront payment under a collaboration proposal, and then it would take for itself 50% of those profits afterwards. They knew all of that. No one disputes that. So here's what plaintiffs say would significantly alter the total mix. The first challenge relates to the August 2020 collaboration proposal from GSK, not the one at the end that's fully disclosed, but the very first offer back in August. Everyone agrees that offer was made. Everyone agrees the company didn't pursue it. The proxy says the board considered it and didn't pursue it. And the plaintiffs say that you can infer that's just a lie. You can infer that when the proxy says the board considered that proposal and decided not to pursue it, we're just lying. Okay. They'd like that inference of a lie to come from one thing, and that's this. At the August 18th board meeting, where the proxy says that was considered, there's no reference to that proposal. If you look at those minutes, it goes through the items that were on the agenda. There's an executive session at the end in which the lawyers at Goodwin Procter who drafted the minutes step out of the room, and it notes that in that executive session, a variety of different additional topics were discussed, but it doesn't mention the GSK proposal. So I submit to you, Your Honor, that the silence in those minutes are not a sufficient basis for you to infer that this proxy is lying. There's a case exactly on point. It's the GGP case below. It has a really nice policy discussion about this, and it points out that proxy statements must be full and complete, and they must disclose all material facts. And if at the end of the day you get to the moment where you're drafting your proxy statement and you look back at your board minutes and your board minutes don't say something, but it happened and it was material, you still have to disclose it. And it also points out our law doesn't prescribe any form or fashion for board minutes. Imagine a set of board minutes that said, at noon on the 18th, there was a meeting. Directors A, B, and C were present in person. Directors E, G, and F were present by telephone, and Director Z was absent. A variety of topics were discussed, and the meeting adjourned at 2 p.m. Those would be perfectly valid board minutes, but when those directors had to put together a proxy statement and ask stockholders to make a decision, they'd still have an obligation to tell the stockholders everything material to that situation.
But you didn't have that kind of minutes here. You had, your friends point out, you had minutes that went into detail on a lot of other matters that may be of relatively less importance. Can an inference be drawn from that, of reasonably conceivable?
I'm glad you asked that question, because one use of the 220 documents, we all agree, is to see whether that reasonable inference is reasonable. So here's what those documents show. Before suit, plaintiffs made a 220 demand. We gave them the board minutes, we gave them the materials, even gave them emails. Here's what they show. A board meeting was scheduled on the 18th. In advance, that was a Tuesday. In advance, the week before, an agenda was distributed. A 97-page board deck was distributed. It follows all the topics that are discussed in those minutes. Then on Sunday, 2 days before the meeting, GSK had made a collaboration proposal. They sent it to Dr. Turtle at the company. They show he immediately forwarded it to Dr. Kumar. They show that Dr. Kumar immediately forwarded it to the directors and said, we can talk about this on Tuesday, obviously referencing that upcoming board meeting. So everything in the 220 documents point in the exact same direction in the proxy. So no, Your Honor, it is not a reasonable inference that just silence in a set of minutes is enough to infer the proxy's lying. I only have a couple minutes left, and so I want to briefly hit on the other disclosure items that the plaintiffs raise. The second one they raise is that we disclose BridgeBio's quote-unquote pejorative view of GSK. So the proxy discloses amongst those 25 pages that BridgeBio met, and it considered that collaboration proposal. And it concluded that it didn't think GSK was a suitable partner. The plaintiffs, and they admit it here today, they don't dispute that's an accurate disclosure. They don't dispute BridgeBio had that meeting. They don't dispute BridgeBio held that view. That forecloses a disclosure claim. This is an opinion disclosure. It is a view of BridgeBio, and they have to challenge the sincerity of that view. But it fails for another reason, and that's malpede. This court says to plead a disclosure claim, you have to identify the missing fact. You have to explain why it would significantly alter the total mix of information. So what's the missing fact? Well, the plaintiffs say they've cited in their complaint a bunch of slideshow pages from GSK. Okay, so is the argument the entire slideshow needs to be disclosed? Or is it portions? And if it's portions, which portion?
But their argument was that the status of GSK and its expertise in this field was misrepresented.
That's their argument. But again, the status of GSK is represented as a statement of BridgeBio. And as the Vice Chancellor below recognized, the proxy makes clear that this is a legitimate multinational pharmaceutical company. It's offered to the terms of its transaction in excess of $2 billion in the collaboration. And the Vice Chancellor concluded, correctly I believe, that given the entire proxy disclosure, there's simply no missing fact identified by the plaintiff that would alter the total mix. That last disclosure claim that plaintiffs bring is that the proxy needed to disclose that GSK remained willing to engage with the company. That's the claim, that we needed to say GSK is still interested in this company. So BridgeBio had no obligation to speculate about that. There's no indication it's clear what GSK was willing to do. In fact, the record shows that GSK sent a letter on December 11th. It can be found at Appendix A520. It states that GSK had determined not to submit a proposal. Now that letter and that decision in the letter is disclosed. It's disclosed in the supplement. That's at Appendix B81. So what GSK said, which is we're not interested in submitting a proposal at this time, is disclosed to stockholders. Proxy doesn't have to go further and speculate that maybe in the future GSK may feel differently. Lurking in there is the notion that BridgeBio had to make a negative disclosure and it wasn't clear enough that that collaboration proposal didn't require its participation. We've gathered those cases in our brief. It's just not required that we go further than disclosing the transaction itself, which everyone agrees we did, and go further than disclosing the terms of that proposal, which everyone agrees we did. I'm at the end of my time if your honors have further questions for me.
Thank you very much.
Thank you for your time, your honors.
Two or three quick points. One, the notion that we failed to plead that the standalone option was non-viable cannot be supported. We plead in the complaint, I believe this is paragraph 46, IDOS lacked the internal resources necessary to independently launch acoramidis, and more importantly, the special committee itself told ISS that. We're years away, and to do it, we have to dilute stockholders. It is plain that IDOS did not have the capacity to independently commercialize. Second, I heard my friends say that the reason our argument about materials being withheld from the special committee doesn't pass muster is because we didn't say specifically what was withheld like they were able to do in a post-trial decision in the RBC case. Well, there's a reason I can't say what was withheld. I don't have the documents. And the reason I don't have the documents is because the special committee didn't have the documents. I got a 220 production with all of the special committee materials, didn't include the follow-up materials that GSK referenced in its November letter. And I think the dual fiduciaries in the C-suite at IDOS withholding information about the GSK proposal from the special committee would be very consistent with their behavior on the very front end of the process. They got the GSK proposal, a multi-billion-dollar proposal, and 2 days later, it's been pushed aside, and they've initiated an MFW process where they're insisting on confidentiality and speed, I think very clearly, trying to get ahead of GSK. And that was an allegation that was just sort of not credited because the proxy says, well, 2 days after, with no materials, no advisors, at a board meeting, which was the first ever meeting for 2 of the 3 independents, most of the meeting is their orientation. At that meeting, this board made a considered determination that the GSK proposal wasn't even worth following up on. This is a momentous decision. The company exists to get a proposal like this from a third party. And yet, in the minutes of the meeting, the 6-page minutes of the meeting where that determination was supposedly made, there is no reference. And let's even credit the proxy. Despite the utter absence in the minutes, let's assume that it was discussed. Well, we know that there were no materials. This is a multi-billion-dollar deal, and the conflicted fiduciaries in IDOS' C-suite didn't even provide any written analysis. They felt comfortable presenting on this at what was essentially the orientation meeting for 2 of their 3 directors who know nothing about the company. And then 2 days later, after it's been pushed aside, now we're going to do an MFW process. We want it to be fast. We want it to be confidential. During the process, we're getting stuff from GSK. We're not giving it to you. It's not a mystery how we ended up where we ended up when GSK came back in.
Thank you very much, counsel. We appreciate the arguments. We'll take the matter under advisement.
Please rise.